So I'm going to explain the two cases which have already been referred to in the previous intervention, and I'm going to make it first with a short introduction just to warm up a little bit. Then I will take up some things which have already been said here regarding the legal background for the cases, in the sense that I'm going to do a very short comparison between the Brussels I regulation and the maintenance regulation. The reason why I'm going to address the comparison is because it's useful to understand the reasoning of the court regarding the decisions, and then I will go to the decisions, not following the chronological order, and the reason why I won't do that is essentially because one of the decisions, the most recent one, has to do with jurisdiction and the other one with enforcement mainly, and there is another practical reason. The most recent decision is easier to explain than the second one, so that's a practical reason. So by way of introduction, I just want to tell you some data on the decisions which may be of interest. The origin of the requests has already been said. Both requests come from Germany. One of them from the Bundesgerichtshof is the one which has to do with whether a public body is allowed to use the same grounds for jurisdiction as the maintenance creditor. And the other one, the one on enforcement, comes from the Amtsgericht Köln. The dates of the request, I think it's interesting to know about that in order to assess how long does it take for the Court of Justice to give an answer to a request for a preliminary ruling. One of them started or was registered in January 2019, and it has been solved in June this year. So it takes more or less 1 year and a half. One has to take into account that there was a hearing, so it means that it's going to take a little bit longer. And also probably the COVID crisis has had an impact, but not that much. So I would really count with 1 year and a half to have a request solved, provided there is a hearing. In the other case, there was no hearing, so the request was introduced in February, and it was solved in September this year. So, as you can see, almost the same period, even without a hearing. But as said, I think that the COVID crisis might have had an impact on this. The subject matter of the cases before the court, as I have already said, one of them has to do with jurisdiction and whether a public body who has been legally subrogated in the place of the maintenance creditor is allowed to use the same grounds for jurisdiction as the creditor himself, and the other one has to do with the enforcement in Germany of a title which had been delivered in Poland, and which is the court in front of which objections can be presented on the side of the debtor. Which was the chamber in charge of these decisions, of these preliminary rulings? In both cases, the same chamber, so a chamber of 5 people, the third chamber of the court, almost with the same composition, and I guess this is good for consistency. The reason why it's almost the same composition and not exactly the same had to do with the fact that one of the judges had to leave in the meantime because he was appointed prime minister or president in his own country. So he had to leave and another judge had to take over. But the juge rapporteur, so the reporting judge, was in both cases the same. And again, this is good for consistency. In both cases, an opinion of a general advocate was required. Not the same. In one case, it was Advocate General Bobek who intervened. In another case, it was Advocate General Campos Sánchez Bordona. And I have to say that in both cases, the opinions have been followed quite closely. Maybe Advocate General Bobek less closely, but because he has a style which is much more academic, so it's more difficult to be followed by the court. You have to see that the court has a very specific way of drafting the judgments. So when there are some academic considerations, they cannot be put into the judgment. And that's why Advocate General Bobek's was followed in substance, but not necessarily in the whole reasoning. So the second point in my presentation, a reminder of the legal background. I know that you are familiar with the maintenance regulation. I expect you to be familiar as well with the Brussels I regime, which means the Brussels Convention of 1968 and the Brussels I regulation, which were the regimes previously in force until the maintenance regulation came into force or in full application. From the point of view of the contents, the regulation, the Brussels 1 regulation, only addresses, or rather, it addresses civil and commercial matters in general, and there was no difficulty in understanding that maintenance matters were also under the scope of the regulation, because there was one article, Article 5, Paragraph 2 of the regulation, which addressed specifically maintenance disputes. The difficulties had more to do with the scope of these maintenance obligations or disputes, but now this has been clarified in the maintenance regulation. The Brussels 1 bis regulation only had rules on jurisdiction and enforcement. The rules on jurisdiction, and this is important to understand further the cases I will explain, these rules on jurisdiction are still subject to a condition, which is that the general rule is that the defendant is domiciled in an EU member state. In case the defendant is not domiciled in an EU member state, then other conventional rules or national rules apply. Then, in the case that the defendant is domiciled in an EU member state, the normal rule of jurisdiction is the defendant's domicile, and the rest of the rules, including the maintenance rule of Article 5, Paragraph 2, apply only by way of exception. It's not exactly that there is a hierarchy among the rules or between the rules. It's rather this idea of there is a principal rule, which is the defendant must be sued at his, or shall be sued at his domicile, and the other rules must be interpreted strictly because they are rather exceptions in order to attract someone outside his domicile. Apart from this way of working of the regulation, there are still some special sections which have to do with weaker parties, so namely a section on insurance, another one on consumer contracts, and another one on employees' contracts. And one could have expected actually maintenance to be a special section within the regulation, because finally we are talking about a maintenance creditor which is supposed to be a weaker party. And actually Article 5 of the Brussels 1 regulation and of the Brussels Convention is conceived as a rule in favor of the creditor, creating a forum actoris. Nevertheless, as said, the Brussels regime did not include the maintenance disputes among the special sections. Then when it comes to enforcement, as you know, exequatur was needed under the old regime. And now I move to the maintenance regulation from making the comparison regarding contents. We have already heard that the regulation, from the point of view of the material scope, is limited to maintenance disputes, of course, but from the point of view of the rules is much broader than the former regime, in the sense that we have rules on jurisdiction, on conflicts of laws, on enforcement and recognition, and also on cooperation between among administrative authorities. The rules on jurisdiction are a closed system which is not dependent upon any specific condition of domicile of the defendant. This entails that no national or other conventional rules on jurisdiction can come into place, or in other words, if you want to sue before an EU member state, either you can make it applying the maintenance regulation and there is a ground for jurisdiction, or there is no ground for jurisdiction pointing to any member state, and then you have to go to a third state. So there is no possibility to apply residual rules on jurisdiction. This is not only the one important difference in comparison to the Brussels regime. The second important difference is that the grounds of jurisdiction are all of them alternative, the grounds that you explained before. They work alternatively. It's for the creditor to decide where to sue, and there is no rule exception principle apply here. When it comes to enforcement, we have already heard that exequatur is not needed. This is not exactly true, and in one of the cases was one case where exequatur was needed. Finally, it did not impact in the final solution that the court gave to the decision, but it had some impact in the reasoning for giving this decision. Exequatur was needed because of the transitional provisions. So the decision on the merits had been adopted in Poland before the maintenance regulation was fully applicable. The enforcement was required afterwards, and according to the transitional provisions in this setting, you still have to ask for exequatur. So now I move to the cases. The first case is the one which was decided just last week, in the 17th of September of 2020, and it's a case, from the point of view of the facts, a very simple case. The mother was the mother of the debtor, maintenance debtor, was living in an old people's house, and she could not pay the rent in Germany. So a public body took over and paid the rent for her. And afterwards, the public body wanted to seek reimbursement from the debtor, who was the son of this old lady. And the question was, well, it was a German public body. Could it sue in Germany, or which would be the normal application of Article 3, Paragraph B of the Maintenance Regulation, or did it need to go to Austria, to Vienna, where the son was living? The German provisions, law provisions, which are interesting in this case are these paragraphs. The one idea, which is very simple: the son had to provide for the mother. And the other one, okay, the son did not provide for the mother, then the public body intervened, and immediately it got legally subrogated in the rights of against the debtor. The question referred was, as I have already summarized, the idea were, can the public body sue at the place of the habitual residence of the creditor, so in this case Germany, or does it have to go somewhere else? Now, why had in this case, the Bundesgerichtshof, why did it have doubts on the application of Article 3, Paragraph B in favor of the public body? Well, it had to do actually with the word creditor. We will see that a moment later. But it had basically to do with a decision which had been delivered by the Court of Justice long ago, when the Brussels regime was still applicable. And the question was quite similar to the one that was asked from the court last year, and it was whether a public body can sue a debtor according to this provision, which was created a forum actoris in favor of the maintenance creditor. And in that case, the Court of Justice, applying the convention, said no, it cannot be. The public body is not a weak party, and it is not being a weaker party, is not entitled to use this favorable ground for jurisdiction. So the Court of Justice overruled this decision and said, nowadays, under the maintenance regulation, yes, you can, as a public body legally subrogated in the rights of the debtor, of the creditor, you can perfectly use Article 3, Paragraph B, and sue the debtor at the place of habitual residence of the creditor, which happened to be, and will normally be the case, the same place of seat of the public body. Which was the reasoning? Well, the reasoning was, I would say the question could have a very easy answer, but nevertheless, when one has a look at the regulation very in detail, one finds that it's always a little bit more tricky than expected. The reasoning followed several steps. The first one is, okay, normally the maintenance regulation can be seen as an offspring of the Brussels regime, so the interpretation should be the same, but actually things have changed, many things have changed in the new regulation, therefore there is no need for continuity in regard to the previous case law. And as I explained before, the maintenance regulation creates a system of jurisdictional grounds which is complete. There is no residual grounds for jurisdiction, and the grounds for jurisdiction are alternative. So if you apply this to the particular case of a public body, and you have in mind the grounds for jurisdiction of the maintenance regulation, you will see that for a public body, even if the grounds are theoretically alternative, it's not very easy to use them, because normally those which have to do with the status of the persons, of the creditor and the debtor, or if there are grounds for jurisdiction or nationality, the common nationality of the parties, they are not going to be applicable, they are not going to apply to a public body. They would apply to individuals, but not to a moral person. Therefore, that entails that from the point of view of a public body, the number of actual grounds for jurisdiction that it could use are not that many. So, finally, summarizing and making it simple, if a debtor is domiciled or has the habitual residence in a third state, the public body could not, if he's not allowed to use the habitual residence of the creditor to sue, probably this public body would have to go to the third state and will not find any possibility to sue in one member state. And this would be for the public body quite detrimental because it would have to litigate abroad outside the European Union. And also, the moment the title comes, in case the ruling is in its favor, it would have to have the title recognized and enforced in Europe, not according to the maintenance regulation, but according to another regime, which may be conventional or national. So that's why, finally, it would not facilitate the life of the public body, which entails that, finally, it would not facilitate the recovery of the maintenance debt. And that's why the court decided that it would be the first reason to allow a public body to use Article 3B would be not to have it suing outside the European Union. The second reason has to do with the interpretation of the regulation, the text, the textual reasoning. If you recall Article 3B, it refers to the habitual residence of the creditor. And according to the regulation, creditor means an individual to whom maintenance is owed or is alleged to be owed. This means not moral persons, this only means individuals, and that's one of the reasons also why the Bundesgerichtshof was not sure about the possibility to apply Article 3, paragraph B to a public body. Well, if you move on in the regulation, you will find that there is a provision which is outside the chapter on jurisdiction. It's Article 64, which has to do with the definition of creditor for the purposes of enforcement and recognition. And there, a public body is contemplated as a creditor. But, again, is for the purposes of enforcement. Now, what happens? If you continue reading Article 64, you arrive to paragraph 3, and you see that here it is about a public body seeking recognition and a declaration of enforceability of a claim which has been delivered following an application of the public body itself. So what we have here is the idea, okay, the public body can be an applicant according to the regulation, and the word creditor is not exactly the same thing as the word applicant or claimant. Actually, this was not so difficult to understand. One only has to go to Article 8 of the regulation, where you has been previously addressed, you have the debtor as the applicant. So, well, creditor is one thing, claimant can be a different thing, so there is no need to apply Article 3B strictly to creditors as individual persons. We can understand claimant in a broader way. The reasoning goes on, and the Court of Justice thought about whether the position of the debtor would be impaired or when a public body is suing him at the place of habitual residence of the creditor, and the court got to the conclusion that no, finally for the debtor nothing much changes because, well, he would be sued by the creditor at his habitual residence, so there's nothing new or surprising or nothing that he could not foresee about being sued at the same place by a different claimant. It could even be that he's more inclined to pay. Well, this is a psychological argument, I would say, is more inclined to pay if he knows that someone which is stronger, like a public body, can attract him outside his domicile and before the courts of the habitual residence of the creditor. And finally, the court took up an argument which I think is quite fashionable, which is the argument of the parallelism foreign use. And it said, okay, the applicable law to the maintenance claimant, according to the Hague Protocol, is the law of the habitual residence of the creditor. The law applicable to the rights of a public body is the law of its seats. Normally, the creditor and the public body are located in the same country. So finally, if the public body can sue at the place of the habitual residence of the creditor, the applicable law would be the lex fori, and this makes things much easier at the end of the day for the court. So this was the first decision. The second one, it's a little bit more complicated. This is the Amtsgericht, the building, and is the preliminary. The preliminary request comes from the Amtsgericht regarding enforcement and also related to jurisdiction. Again, the facts of the case are quite simple, quite common, I would say. A girl was represented by her mother, claimed maintenance from the father in Poland, and the court ruled in favor of the claimant. Some years later, the mother sought the enforcement of the decision in Germany, where the father was currently living. It had to us, as I explained before, it was not a direct enforcement of the title because exequatur was needed, and exequatur was granted by the Amtsgericht Köln. Then the father introduced an application against the enforcement, claiming that he had already paid, so he had already fulfilled his obligation, either directly paying to the mother, to the children, or to a maintenance fund who had taken over his obligation. So he claimed that the debt was over. So the applicable German provisions in the case at hand, well, some of you are perfectly acquainted with them. One of them tells you that you can object with objections which actually you could have normally raised before the court who is deciding on the merits. You can still use these grounds for opposing enforcement if they appeared, let's say, after the close of the hearing, which was the last opportunity to challenge the decision on the merits. So it's a question of time. And then the other provision which was in the mind of the Amtsgericht Köln was this paragraph 66 of the Auslandsunterhaltsgesetz, which establishes where you can apply against enforcement. And it says you can apply against enforcement before the same court which is ordering enforcement. So, which were the doubts of the Amtsgericht Köln? And here I'm going to talk about something which is properly German. So I ask for forgiveness in case I'm saying something which either the court did not understand properly or I didn't understand properly. Apparently, there is a different way of understanding this problem from the side of the German legislator and from the side of the German literature, in the sense that from the point of view of the German government and the legislator, it seems that an action against enforcement is something that does not fall under the scope of the maintenance regulation because it is primarily enforcement. Therefore, it falls under the scope of the Brussels regime. Under the Brussels regime, there is this particular provision, which is Article 24, Paragraph 5 of the Brussels 1 bis regulation, which establishes an exclusive jurisdiction of the court which is dealing with enforcement to decide on every issue that has to do with enforcement. So, as I said, it seems that from the point of view of the German legislator, this is what should apply also to an action against enforcement in maintenance matters. According to the German literature, on the contrary, the maintenance regulation applies, and the rules on jurisdiction which apply are the normal ones, meaning Article 3 and the following. Basically, they say because functionally, when a debtor is opposing enforcement on grounds like this one, I have already paid, the question is functionally the same as when there is an application for amending the maintenance claim. And this is something that falls under Article 8 of the maintenance regulation. So maybe you remember this is something that has already been said here. If the debtor asks for changing the maintenance decision, he can only go before the court who decided on the merits in the first place. So this was the problem of the Amtsgericht Köln. It didn't know how to do. The problem had rather to do with the lack of common opinion in the German setting, I would say. So it asked for the interpretation of the maintenance regulation, asking these two questions. So does this opposition against enforcement fall under the scope of the maintenance regulation? And if not, are we under in the framework of Article 24.5 of the Brussels regulation? The court decided that an action or an application opposing enforcement does fall under the scope of the maintenance regulation, so the Brussels 1 bis does not apply. And not only this, but it also solved the problem of the grounds of jurisdiction, saying we don't apply the normal grounds for jurisdiction, Article 3 and the following, but Article 41 of the maintenance regulation. What was the reasoning of the court? Well, the first idea was, even if we are talking about enforcement is not a subject material, substantive matter as such. Enforcement is always about something substantive, like, for instance, maintenance. So finally, we are discussing about maintenance. Therefore, we are under the maintenance regulation and not under the Brussels 1 bis regulation. And then it followed on, is there any gap in the maintenance regulation in the sense that we don't have anything similar to Article 24 of the Brussels 1 bis regulation? And it said, no, there is no gap, because it's true that there is actually, in the text of the law, there is no ground for jurisdiction, but Article 41, which is already in the sections for enforcement, implicitly indicates which is the competent court for dealing with applications like the one in the case at hand. So it is the court which has to enforce the decision, is the one which has to decide also against on the opposition to enforce. The court then took up the different arguments of the Amtsgericht Köln and also of the observations of the parties who intervened in the hearing. And it said, well, would it be sound, nevertheless, to apply the normal grounds for jurisdiction, so Article 3b in the case at hand? And it said, well, from the point of view of the protection of the creditor, yes, because the creditor then, let's say, rather the other way around, the debtor would be opposing enforcement in the place of habitual residence of the creditor, so in this case, in Poland. So it looks as if, from the point of view of the creditor, this would be a better solution, which would be would comply with one of the main principles, overriding principles of the regulation, which is the protection of the weak party. Nevertheless, the court said, well, this is not the only principle which is we have to take into account. We should also take into account that the good administration of justice, in general, talking in general, and we have to take into account that there are two parties, there is a creditor, there is a debtor, and we need to find a balance between the two parties. So finally, if a debtor needed to go to the habitual residence of the creditor, it would be detrimental for him. So it makes sense that he can oppose at the place of enforcement. And from the point of view of the time that is spent in deciding this, it seems to be much quicker to decide on the place where enforcement is sought than going back to Poland. So this was the first one of the first argument, the second argument of the court, apart from Article 41. Then it took up the question of whether an action opposing enforcement is functionally the same thing as an action to modify the decision on maintenance. And the court said no, because, and there I think it's right, Article 8 is more thought in terms of a debtor or a creditor whose vital circumstances have changed. So, for instance, the debtor is not working any longer, or the creditor gets married and gets support from the new husband or wife. So this is the constellation which is rather foreseen under Article 8. Whereas in the case of someone saying that he has already paid, from the point of view of the court, this is not modifying the decision. The title remains existing. It is only the amount which is modified. So therefore, we are not under Article 8 of the regulation, and we are not either in a setting where the decision on the merits is being reviewed as to the substance. Because, as I said, the title exists, the creditor is entitled to maintenance. The only thing that changes is the amount of the award. And then the other thing, and this has to do with what I said before, exequatur was needed in this particular case, and the court nevertheless reasoned using a provision which would only be applicable if exequatur had not been needed. Nevertheless, I still think it was not that bad. If you, in a setting where exequatur is not needed, you may remember that the debtor can still oppose enforcement. Some of the grounds are given by the regulation itself. Some of the grounds are those which exist under national law, provided they do not contradict those which are in the regulation. And according to recital 30 of the regulation, one of these grounds which can be used against enforcement is that the debtor has discharged his debt at the time of enforcement. So the court said, if this is valid in a setting where exequatur is not needed, and we go directly for enforcement with the foreign title, this should also be useful when exequatur is still needed and we are already moving to the enforcement stage of the proceedings. And, well, finally, the court also addressed, and for this I think I have no slide, addressed also the fact whether the a maintenance fund had